For reading 3.3, I thought it was a good idea if we went through and discussed the types of opinions most appellate courts writes, and at least with regards to the United States Supreme Court, what that process of opinion writing looks like. So on the United States Supreme Court, the opinion writing process is pretty structured, but we know about that process primarily through two sources: private interviews that the justices and their clerks give, and also very detailed records that certain justices have kept from their time on the court and then released public after their death. So we know that after the voting process takes place, which we covered in a previous video, the most senior member of the majority coalition, that usually is the United States the Chief Justice of the United States Supreme Court, or the most senior member if the Chief Justice is not a member of the majority, chooses to assign the opinion. And they can sign it to themselves, or they can sign it to any other member of the majority. Once that opinion is assigned, a draft of the opinion based upon the reasoning discussed at conference is written, and then that draft is circulated. And that draft isn't just circulated to the individuals who voted with the majority. That draft is circulated to everyone who sits on the court. And this allows the individuals sitting on the court to negotiate and bargain and strategize over the content of the judicial opinion. To that end, from the initial draft to the final publication of the opinion, a significant amount of text, points of law, precedent, citations, and so on can change with regard to the actual context of the opinion. In that writing process, other opinions may occur. So let's go through and talk about the other type of opinions outside of the majority opinion that occur in appellate courts. If you agree with the outcome of the case, but you disagree with the reasoning that was used in the outcome of the case, you can issue what is known as a concurrence. In most appellate courts, what this means is that your vote counts with the majority of the court in terms of which party wins, but you disagree with the majority about why that party should win. You might prioritize a different point of law. You might think that it's a much simpler issue than having to answer on the merits. You might think, for example, it's a standing issue, that the party didn't have standing, and even though they lost, that they should have never had the case to begin with. And so these variations can lead to a concurring opinion. Another type of opinion that a court may write is a dissenting opinion. You should be pretty familiar with these. That's an individual who disagreed in the outcome of the case. They will write their reasons why they think that the majority opinion is wrong. And the interesting thing about majority opinions and concurrences is they can affect significantly the text of the majority opinion. Reading 3.3 talks about this on the Danish Supreme Court, how a dissent can affect what the majority opinion says. In fact, in their context, they say that the majority opinion lengthens significantly in the face of the dissent. And I would call that one sort of strategy that can happen. Either you will respond, the majority opinion can respond to the dissent and sort of write in why they think the dissent is wrong, or they can completely ignore it and write a much more simple opinion, put the blinders on and ignore that the dissent occurs. And we see both of those take place in the American context. There's one other type of opinion I want to focus on that is used in the United States, and that is what is known as a per curiam opinion. Per curiam translates for the court. What a per curiam opinion is it's a majority opinion that is unsigned but carries the weight of a regular majority opinion. There are some reasons why you might want to issue a per curiam opinion. Let's say, for example, you're on a court that deals with a large number of a particular type of case. They all tend to go the same way. Really, you're not setting precedent with these. And so in a very informal per curiam opinion, perhaps no more than 4 lines, you can dispense of the case very quickly. As an example, Florida, with the Florida Supreme Court, which has mandatory jurisdiction to hear all death penalty appeals, long ago, in really the 1980s, adopted the practice of issuing per curiam opinions for death penalty cases, because most of them really don't, the issue isn't like changing the precedent of law, and so these very quick, unsigned, fast opinions dispense of issues very quickly. But that's not always the case. Perhaps the most famous per curiam opinion is actually Bush v. Gore. Bush v. Gore was decided in a 5-4, very closely decided case in which the presidency was in essence handed, correctly or incorrectly, it really doesn't matter, to George W. Bush when the United States Supreme Court stopped the recounts in Florida. Now, the majority opinion was issued per curiam, which simply means unsigned, but we know what the vote in the case is because 4 justices wrote dissent. So there were 4 dissenting justices which joined on, and so we could easily count that we knew the majority was 5 and we knew the minority was 4. But we don't know who the author of the Bush v. Gore opinion is. And so another strategy which may be used and employed with per curiam opinions is simply shielding the author from any sort of retribution, any sort of accountability. Now, this is exceedingly important on state Supreme Courts, because if you write a majority opinion in which the majority opinion author is writing something very controversial, let's say, for example, overturning a death penalty case in Texas. Let's say the Texas Court of Criminal Appeals issues an opinion that overturns the death penalty. Let's say it's unanimous. So like the law is clear, the decision was clearly out of step. The law pretty much mandates that this case has to be overturned, or at least remanded and sent back. Judges know that any time they overturn a death penalty case, that will raise the ire of any number of individuals within the public. So a per curiam opinion in that sense would shield the author, in fact, it shield the entire majority from any sort of retribution because it couldn't be pinned upon one individual. So the per curiam opinion can be used as simply a time-saving device, or it can be used in a very strategic way. That's really kind of the beauty of the per curiam opinion. But it's just one of many types of opinions that appellate courts can issue.